Thank you for the opportunity to testify today in favor of Assembly Bill 103. My name is Luke Berg, and I'm an attorney with the Wisconsin Institute for Law and Liberty. I have been our lead attorney on our parental rights litigation. As you're probably aware, multiple school districts in Wisconsin have policies to allow and facilitate children changing gender identity at school without notifying the parents or obtaining their consent. Some districts will even hide a transition at school from the parents. Imagine discovering that for months, school staff have been treating your daughter as if she is your son, or vice versa, without you knowing about it. I've received that call from far too many Wisconsin parents in the last few years. These policies violate parents' constitutional rights to raise their own children, and we have brought lawsuits against 3 Wisconsin school districts on that basis. We won our lawsuit against the Kettle Moraine School District, but other districts continue to have these poorly thought out policies. The legislature has a chance to correct this issue statewide to protect parents and their children, and it should do so, as other states have done. The premise of these policies is that the only appropriate response when a child questions their identity is to immediately and without question affirm that the child really is the opposite sex. Think about how bizarre that is for a moment. We don't treat any other issue that way. No good parent gives their child anything and everything they want, no questions asked. Nor do we make medical decisions based solely on a child's self-diagnosis. Part of our job as parents sometimes is to protect our children from themselves. Moreover, a robust body of research has shown that most children who struggle with this eventually desist. That is, they return to comfort with their biological sex. But desistance drops dramatically.
No comment, not you, sorry. No comments from the audience.
Desistance drops dramatically for kids who transition. Because of this, many experts believe that treating children as if they are the opposite sex can do long-term harm by reinforcing a false belief. For that reason, many countries in Europe now recommend a slower, more cautious approach where the first step is psychotherapy to help children process what they are feeling and why. These school district policies effectively take that option away from parents. Whatever you think about this issue, it's beyond dispute that transitioning is not right for everyone, and for some, it does harm. More and more young people, especially girls, are telling us that this was their experience. You're going to hear from one in a moment. If you listen to their stories, they often say that they wish someone had the courage to tell them the truth about who they really are, not just what they wanted to hear at the time. The bill allows parents to decide what's best for their own children. That's consistent with what parents expect when they send their children to school. Anything out of the ordinary requires parental consent. Field trips, sports, taking an aspirin at school. These are far less significant than changing gender identity. As Judge Maxwell put it in our case, the school district could not administer medicine to a student without parental consent. The school district could not require or allow a student to participate in a sport without parental consent. Likewise, the school district cannot change the pronoun of a student without parental consent. I would hope this would be a bipartisan issue. We can disagree about when and whether a transition is the right answer for children struggling with their gender. But we should all be able to agree that parents who know and love their children more than anyone else should be the ones to decide what is best for their own children, not school staff who barely know them. I would urge your support for the bill, and I'm happy to answer any questions.
Okay, thank you. Do you have any questions? Representative Snyder.
If a trans student is having a traumatic home life, kind of fearful of the parent learning this, teachers are mandatory reporters. Can they report this to protective services and they can intervene and try to at least get the ball rolling for some kind of understanding or remove the child from the home? Or does that even measure in this case?
Yeah, that's a good point. I certainly don't disagree that there are bad parents, but we have a system and a process in place to deal with that, and it's the Child Protective Services process. And that process provides parents with due process, notice, a hearing, a right to be involved, and it has a high substantive bar to displace parents. And the problem with these school district policies is that it doesn't provide any process, and it doesn't have any substantive bar. It's solely at the say-so of a child who says, I want to change my gender, and I don't want my parents to know about it. And that violates, in our view, that violates parents' constitutional rights, it violates due process, and it circumvents the whole CPS process. So I I completely acknowledge the point. There are situations where parents are problematic, and I think the Child Protective Services process is equipped to handle those situations.
Representative Dietrich.
Thank you, Mr. Chair. Thanks for being here, Luke. Two questions that came up, perhaps you can answer. Are you aware of how many school districts are adopting this sort of policy already?
I haven't done a statewide survey to give you a number. I know currently the Milwaukee School District has this policy, the Madison School District has this policy, the Eau Claire School District has this policy. There's a group called Parents Defending Education that has been compiling a list of school districts that have policies like this. They currently have 11 school districts in Wisconsin listed. I don't know the extent to which they've checked that monthly to see whether that's been updated. It's possible they've missed some, but I know there are a number of school districts who have this policy in Wisconsin currently. And again, as I said, I have received this call from a number of parents who had this happen to them. And we're also aware of situations where a school district follows this policy without having it written down. So that was the situation in Kettle Moraine. They didn't have a written policy. So even if you searched for it, you wouldn't be able to find all of the school districts that have this policy because some of them are applying it without actually adopting it in a formal written policy.
A follow-up question quickly also. Are you aware of any lawsuits because schools are enacting this sort of policy?
Yes, many. We at the Wisconsin Institute for Law and Liberty have brought 3 of them as
Oh, I meant against the policy.
Oh, against a policy of parental consent. No, I'm not aware of any except for 1 or 2 in California and New Jersey. The attorney generals in those states have taken the position that schools cannot include parents in these decisions. I think those lawsuits will lose, but we'll see. I will say in the other direction, however, there are roughly 40 lawsuits around the country against school districts for hiding gender transitions from parents. So I just think the law is in favor of parental rights in this situation.
Thank you.
Representative Duco.
Thank you, Mr. Chair. I just want to clarify what you just said. You said Milwaukee has a policy in place?
Yes.
So MPS, the largest school district in the state with 70,000 children, already has this policy in place?
Yes.
Thank you very much.
Representative Hahn.
Thank you, Chair. You're an attorney, correct?
Yes.
Are you aware of any case law that states that parents have a constitutional right to know their child's gender?
I'm aware of case law that says parents have the right to make decisions concerning the care, upbringing of their children. There's a long history of cases from the United States Supreme Court that say that. How that applies to this specific scenario is an ongoing issue in litigation. We brought one of those cases against the Kettle Moraine School District, and we won the case. And yes, the court held that a school district ignoring parents' decisions about the name and pronouns that their child should be addressed by at school, ignoring the parents' decision about that violates parental rights. There are other district courts around the country that have found that as well. There's one in the Southern District of California, one in Kansas. There's a number of them. But it's an ongoing issue. It's being litigated around the country currently.
Appreciate that background. In the case that you lost, what was the decision by the Supreme Court?
Two of the cases that we had ended without a decision on the merits.
Okay.
So the case against the Madison School District was mooted because all of the 14 parents that we had as plaintiffs left the school district before we reached a decision on the merits in that case. The case that we had against the Eau Claire School District, we lost on standing, which is the view that parents can't preemptively sue to challenge one of these policies until it's been applied to their child. Now, I think that decision was wrong on standing law, but that's what the federal district court said. That's what the Seventh Circuit said. So that wasn't a decision on the merits of one of these policies. It was just about whether parents can sue preemptively to stop it.
And I just want to clarify, it's because they did not experience a legal injury to themselves and therefore lacked legal standing.
That was what the federal courts held. Again, I think that decision was wrong.
Okay.
Seventh Circuit is not the final say on that, but that's my
Appreciate the
view.
clarification. You mentioned far too many parents have reached out that this is a bipartisan issue. When those parents reached out, did they mention that it was their child who had not, that they did not give permission to do a legal name change, or were these far too many incidences regarding a policy that they did not agree with?
These were parents who discovered one day that their school district was treating their child as if they were the opposite sex at school without them knowing about it.
So treating the child, identifying the child by their preferred name and pronoun, but
Yes.
not a legal name change.
Identifying the child by a name and pronouns at odds with their biological sex without having notified the parents or obtained their consent before doing so.
But these are interactions between a teacher, a special education assistant, some of the amazing folks that work in our school. Addressing a student by their preferred name or pronoun was a complaint of a policy not being in place for them to know about these conversations, not a legal name change.
I'm not sure I follow the question. Can you reword it? Sorry.
So the parents who reached out about their child, concerned that the child was being called by their preferred name or pronoun, that the school did not alert them of it, was the concern?
Yes.
Okay, but it was not regarding the child's pursuit of a legal name change.
Yes.
Okay.
In the situations that I have heard about, the child had not pursued
Sure.
a legal name change, but had sought to informally change their name at school, asked staff to begin calling them by a different name, using different pronouns. Staff began doing that without obtaining parental
But
consent.
it was
which
what
is
the
part of
student had
problem.
asked the staff to do. I would assume that's why the educators,
Presumably,
the people in
yes,
the room
although
wanted to do that.
What we're
Okay.
talking about is minor children, and so this conversation in the context of an adult and a child, it's hard to know what happened in that situation.
And I like to think that children have agency, deserve to have their rights and freedoms respected and acknowledged. And I think that, every child has the right to be their best selves. Relationships involves how you become someone involves, and involving ourselves in that process could often be a disservice. I have one more question. Again, you said far too many. How many is far too many? How many exact instances, numbers? Because I'm assuming if you're going to create this case, you're going to list how many parents, individual parents, reported incidences of their child being called by their preferred name and not being notified. How many parents?
I would say in the range of 6 to 12. I don't know
6
the
to 12.
exact
Okay,
number.
thank you. Thank you.
Knock it off. Go ahead. Are you done? Okay. Representative Duco?
Thank you. I'd like you to clarify something for me. Representative Hong seems to have an issue with the legal name change. If a child has a legal name change, obviously the parent has to do that if they're under the age of 14 to change their name, correct?
Yes.
So if they have a legal name change and they go to the school and they say this is now their legal name, the school is going to abide by that and use that new legal name, correct?
Yeah, that's my understanding of the bill, is that if a child legally changes their name and the parents submit evidence of that to the school district, then the school district will update the records to reflect that. Yes.
Thank you.
Maybe Ledge Counsel can help on this one. A 14-year-old wants to change their name. Do they have to petition the court and the parents got to know about it, or they can do it without any?
They petition the court, and whereas if you're under 14, your parent or guardian has to
Right.
petition the court.
But if you're 14, they don't have to petition the court?
No.
Okay. Okay.
Anyone else? Okay. Well, thank you.
Thank you.